All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You may be seated.
We'll hear argument this evening in case number 24-1435, State of Ames versus Daniel Wells. Mr. Seabrooks, please proceed.
Madam Chief Justice, and may it please the court. My name is Gregory Seabrooks, and along with Ms. Lee, we represent the State of Ames. We'll each argue for 16 minutes, Ms. Lee on issue 2 regarding sovereign immunity, and myself on issue 1 regarding the takings clause. We'd like to reserve 3 minutes for rebuttal. 5 years ago, in the Supreme Court case Maine Community Health, 9 justices affirmed what has always been true. The takings clause does not provide an express cause of action, which means that litigants—
Can I ask you a quick question about this right out of the gate, just to make sure that I've got the terminology correct? So Maine Community Health says no express cause of action. Does that mean necessarily that we are in implied private right of action land, or is there something in between? Like the parties talk about a direct cause of action, is that a different thing?
Well, we would argue that there is no express cause of action under the takings clause, and that de Villiers, in Maine Community Health, when they said there was no express cause of action, they were relying on the Tucker Act to provide the missing ingredient. That's what the court described it in Borms. The missing ingredient in that case was a waiver of immunity and the supplying of jurisdiction. So there is no direct cause of action directly under the takings clause, but when you have it in conjunction with things like the Tucker Act, that allows certain tribunals to have a cognizable claim where you can seek just compensation.
Now, why?
Well, I actually wonder if the Tucker Act is a real problem for you, because I don't see an express cause of action in the Tucker Act. It seems like it vests jurisdiction in a particular tribunal and it has a waiver of sovereign immunity, but it doesn't have any kind of express cause of action. So I would have thought that the Fifth Amendment came in and supplied that cause of action and claims against the federal government.
Respectfully, Your Honor, we would disagree that the Tucker Act does not provide an express cause of action. We acknowledge that that may be true on its own, but when you look at what the framers or what the Congress intended when they passed the Tucker Act, it's clear that they had an intent to allow for the takings claims brought under the Fifth Amendment to be cognizable in the Court of Claims. But the key point here is that Congress intended to create a jurisdiction where claims against the United States government can be heard. And that's our first reason that the lower court is incorrect in its decision to find an express cause of action.
But to Justice Prelogar's question, the Tucker Act on its face, right, provides for jurisdiction and waives sovereign immunity, but missing in the middle is any cause of action. So what provides the cause of action other than some extra textual intent?
Well, if you look at the underlying claim, which we agree does automatically arise when you have property taken without just compensation, that claim for decades could not be heard in any tribunal except for Congress, who passed private bills to provide for just compensation. So our argument is that the Tucker Act allowed for that claim that existed, that obligation that existed, to now be heard in a court. And that underscores our point. If Congress wants for a specific type of claim to be heard in a tribunal, whether it be Article 1 or an Article 3 tribunal, Congress must act. And that's what it did when it passed the Tucker Act.
But it seems as though what you're saying is that we should imply a cause of action for just compensation under the Tucker Act, which, as we've said repeatedly, does nothing more than create jurisdiction and waive sovereign immunity. If we're going to get in the business of implying causes of action, doesn't it make more sense for us to imply that cause of action under the takings clause itself, which is actually the legal authority that creates the substantive right at issue, as opposed to looking to a jurisdictional provision?
In cases like Armstrong, the court has explained that implying causes of action directly under the Constitution is a bit more dangerous because they are congressionally unalterable. If the courts had gotten it wrong when it came to Tucker Act jurisdiction and what the United States meant to do, Congress could have overturned the Tucker Act, modified it, or changed the law to provide more direction. But when we say the framers intended X, Y, or Z under the Constitution, it's very hard to change that absent an overruling of that decision by this court or some other constitutional amendment.
How much danger is there in that really, if the state of Ames is, as far as we know, the only jurisdiction in the United States that does not provide some mechanism for individuals to get just compensation when their private property is taken by the government? Is that a legitimate risk that we should be concerned about?
Your Honor, we do believe that it's a legitimate, or that is a legitimate risk because, one, on the record, it's not very clear that the state of Ames has no mechanisms altogether for providing just compensation. What the record provides is that we don't have inverse condemnation, but that's true of states like Ohio, and it also provides that we don't have a just compensation takings clause in our Constitution. That's true of states like North Carolina. But every state and every officer in each state has an obligation to uphold the Constitution, and there's no indication on the record here that Ames does not intend to do that. But if Your Honor, if you are worried about the state of Ames or rogue states in general not supplying a way to get a remedy, there's a cause of action for that, and there's equitable powers that this court can exercise. If the court found that certain states were depriving all individuals of remedies for redress, that would be a due process clause violation. But that does not mean that you should create a cause of action directly under the takings clause that would apply to all 51 states.
So what are the benefits of thinking of this as a due process problem as opposed to a takings problem? If a litigant were to bring a due process claim in state court, would that individual be entitled to a monetary remedy in your view?
If the individual brought a due process claim in state court and then it was eventually found that they got no monetary damages, the Supreme Court of the state of Ames said there was no right to monetary damages, this court can do what it did in cases like Poindexter, where it says, if you're going to say that your state officials are shielded from liability under common law torts, then your state officials must follow the law. But in the case that they do not provide just compensation, there would be no lawful reason for them to be shielded from liability. So the action in that case would be against the individual officers, and that's how it was enforced at the founding.
Can I take you?
Please go ahead.
Can I take you back to your contention that there would be a real risk of inferring the cause of action from the Constitution itself, and it might open the floodgates, and there's no way to undo that? I guess I think there's a very natural limitation built into the Constitution, which is that this is a special provision insofar as it sets out a right and specifically demands a remedy. And I wonder why we can't just look at that specific combination, which also applies to habeas corpus, and find that with those limited constitutional rights, there should be a cause of action that's self-effectuating under the Constitution itself.
The right to a remedy did not create a cause of action at the founding, and with respect, the writ of habeas corpus is a bit distinct. The writ of habeas corpus not only enshrines the judicial remedy of habeas, but it also enshrines the cause of action itself, the word writ. So the privilege to apply for a writ of habeas corpus is actually an example of what the founders could have and should have done if they wanted to enshrine a right to just compensation that would be judicially enforceable. So that sets up an excellent contrast with what just compensation clause does. Our contention is what de Villiers said in 2024, which is that the takings clause gives rise to an obligation, but does not specify the procedural vehicle. We're not just saying that the text is silent as to who's going to enforce it. We say instead, look at other provisions in the Constitution for that answer. If you look to the appropriations clause, or if you look to the tax and spending clause, they clarify that Congress is in charge of making sure that monetary claims are paid.
But I'm worried about your reliance on Congress here and Congress's appropriations power, the power of the purse, because of course this is a lawsuit against a state, and we don't normally think of Congress as having primacy over whether you can get money damages against a state. And this is an individual right, and a very important one at that. So why should we be focused on Congress's prerogatives?
Well, first, the fact that Congress believed in the early days that it had authority to adjudicate these claims is an indication of what the framers understood the takings clause to mean. So we think the first thing that you could take from that is that they did not understand to create its own cause of action. But second, we see that Congress has acted in the past to ensure that state officials are held responsible for violating federal rights. For example, in the Jim Crow South, they passed 1983 that allowed state officials to be sued for violations of your federal right. Mr. Wells, if just compensation had been denied, still retains the right to bring a 1983 action in federal court, and that's a way of holding the states responsible by holding the state officers responsible. We think that it would be dangerous for this court to say that 1983 is either superfluous or that they got it wrong by holding the state officers liable by creating a new cause of action here that would flow directly against the state.
So do you concede that if Mr. Wells were to bring a 1983 suit against the individual state employee who was responsible for shutting down the hand sanitizer factory and converting it to government use during the COVID emergency, that lawsuit could go forward? It seems like a pretty transparent end run around all of the federalism and separation of powers concerns that you've been describing, if all he has to do is relabel the defendant.
Well, we think that that's the end around that Congress endorsed when it passed 1983, and it's different when Congress does it as opposed to the courts. We think that when Congress enacts the statute, such as 1983, they also set up different procedural mechanisms to ensure that that statute's going to be enforced equitably and consistently. But by creating a direct cause of action under the Takings Clause, that brings a lot of the harms that we saw in Bivens when it comes to what's the actual statute of limitations, what's the class of defendants.
Can I ask you just about Bivens? I recognize that Bivens is sort of out of vogue, that implying private rights of action kind of out of vogue. But to the extent there were ever a case that a Bivens-style remedy were appropriate, or that fit Sandoval, frankly, to a T, private right, private remedy, why isn't this it? If we were ever going to recognize an implied private right of action, be it under the Constitution or even using a statutory analog, why isn't this the case?
Well, if you take Sandoval for what it also says that if the text and structure are clear, you need not go beyond that instrument to discern the relief. Here, we say the text and structure are clear, that Congress in the first instance is to make these rules when it comes to paying compensation for claims against the United States government.
So just so I'm clear, how is the text clear that this job is delegated to Congress?
Well, the Appropriations Clause, for one, says that all payments from the Treasury must be authorized by Congress. And in cases like OPM v. Richmond, this court has explained that that's an explicit rule of decision. It's a bit tense to say that the judiciary is also authorized to now have a cause of action where they can open up the Treasury of both the United States government and possibly the states. It's hard to read that in conjunction with the Appropriations Clause.
But is there a difference between a court's power to issue a judgment requiring a defendant to pay a certain amount of monetary damages and the requirements to, as used to be the case in our nation's history, to then go to Congress and ask for appropriations to fulfill that judgment? I understand your friends on the other side are really just asking for step one and are willing to set aside step two.
Well, we would say that if you're just asking for step one, which is the ability to bring your claim before the court to get some type of relief, we think that you can bring Tinker's claims before federal judiciary for equitable relief. That's where the court can issue injunctions if that's appropriate, or issue a declaratory judgment saying that the law that you purported to do the taking under was unlawful and it does not shield you from liability in certain common law torts. But for this court to create its own cause of action would again be in tension with the Constitution, which provides in Article 3, Section 1, that Congress is responsible for establishing the jurisdiction of the lower federal courts.
But I'm not sure why you think an injunction is an appropriate remedy here, because the premise of the Fifth Amendment, incorporated against the states through the 14th, is that the taking can occur. You don't have to stop that action. It's just that you have to pay for it. And so it's meant to balance those competing interests. And it feels like some of the alternative remedies that you're offering here wouldn't carry out the design of that constitutional amendment.
Well, we don't think that an injunction will be appropriate in every case, but again, we do take the point that a 1983 action is available. And to answer the question earlier, yes, we would say that a 1983 action would lie, assuming the allegations to be true in the complaint. If someone took property for public use without providing just compensation, that would be a perfect example of where a person could bring a 1983 suit and hold that officer responsible for violating the law. In this case, they can do so against the individual officer in his individual capacity. The arm of the state doctrine would not necessarily apply to that and block that. And our opposing counsel, they say that the qualified immunity would protect those officers. That's something to debate if they bring that claim on the merits, but it's hard to see how when the Fifth Amendment provides an explicit rule of decision, qualified immunity would protect someone in a physical takings case. A lot of the cases they cite for saying that qualified immunity would protect a state officer are regulatory takings cases, not physical takings cases, where the law may be a bit more muddled. But here, there are alternative remedies that are available that should caution this court before creating a new cause of action that's not just applicable.
I guess what I'm worried about is all of those remedies, it sounds like, would be kind of a strange way to deal with the taking. The usual remedy is the payment of just compensation. That's the remedy that's in the Constitution. And so I'm a little bit worried about the consequences, because it seems to me like if we rule in your favor here, nothing would stop all states from eliminating any inverse condemnation action and refusing to pay just compensation. And that would be a really dramatic shift in private property rights and in what the framers intended with respect to the Fifth Amendment scope.
Well, if you look to opposing counsel, I think they cite 14 different cases that are takings clause cases. 8 of them were common law causes of action against individual officers. 2 more were ones where the state itself initiated the action. But never have you seen that the state is on the other side of the V. The state is the defendant. So the real anomaly here would be the relief that they request, which is an action against the state itself. And I hear your concerns, Chief Justice Prelogar. If there was a massive wave of states taking away their inverse condemnation and taking away all other remedies, because we do think the states allow allow different remedies to be in, for example, in courts of claims in their own jurisdiction or administrative bodies. But if they took away all remedies altogether, that would give rise to a due process clause violation.
I'm glad you circled back to that. Can you kind of sketch that out for me? It just seems like a lot of gymnastics to say we've got this provision in front of us that says, if there's a taking of property, just compensation is owed. And you say, no cause of action there. Instead, sort of if all hell breaks loose, then we can go to the due process clause. Sketch out the due process claim for me. What does that claim look like?
So, for example, if you take cases like Poindexter, that was a case where the tax collectors in the state took someone's private property as they were litigating out whether or not more taxes were due. And the statute in the state of, I forget exactly what state it was, but the statute there protected the tax officers from liability from common law actions. The person there raised a due process concern, saying that there's no way for me to remedy the violation of my rights because my property was wrongfully taken. The state affirmed that reasoning, but then the Supreme Court reversed, saying that you must allow the common law action to be asserted against those officers. And that allows for the type of relief that was consistent at the founding, where you brought common law tort actions against individual officers, not just for all claims, but also for just compensation. That's our entire point.
Why are you fighting so hard then? It seems like you really don't want us to infer that this cause of action can be brought directly under the takings clause, but then you're offering up these other examples, and I guess I don't understand what's at stake. What does the state gain by having this adjudicated through the prism of this kind of novel theory of due process in this context?
Well, first, what the state loses with a direct cause of action under the takings clause is the ability for it to define its own remedial scheme, whether that be through specific tribunals, administrative bodies, or have its own court of claims that has expertise on local property issues. And instead, what we would see is basically an unbridled opinion where the judicial authority can be asserted in a vast array of state issues, quintessential local issues.
And that's how that's fair to your opponent's argument. I understand their argument to be, courts have to follow the legislative guidelines if there are legislative guidelines. But if the legislature has not deigned to provide any sort of mechanism for an individual to receive the just compensation to which they're constitutionally entitled, then at that point courts step in. What's wrong with that?
We would argue that the court has never before authorized monetary claims against the state when it is not providing the remedies that is due. Instead, what has happened is 1983 actions could lie, or the court said that you must provide some procedure for remedying the wrong. That allows the state to retain its discretion in crafting that remedy, but still clearly enforces the law and says that you must provide a remedy at the end of the day. For these reasons, we do not think that the Supreme Court should affirm the lower court's decision below. We ask that you reverse. Thank you.
May I proceed? You have to call me over.
Ms. Lee, please proceed.
Thank you. Madam Chief Justice, and may it please the court. This court has made clear that there are only two circumstances in which an individual may sue a state. First, Congress may abrogate state sovereign immunity by using its Section 5 authority. And second, a state may waive its sovereign immunity. No party suggests that Congress has authorized respondent suit, so that just leaves waiver. But there was no waiver
Can I
in
ask
this
you
case.
before we get to abrogation and waiver, just about the terms of the 11th Amendment itself, right? The other side sort of nods in the direction of saying, hey, don't forget the 11th Amendment only applies by its terms to suits brought by citizens of other states. They don't expressly ask us to overrule Hans, but there's this whisper. And what do you say to their argument that outside the four corners of the 11th Amendment's terms, all we really have is some common law-ish background principle of sovereign immunity that at the very least should give way to the express terms of the Takings Clause?
Your Honor, as a matter of history and original understanding, I think the ship has sailed a little bit on that interpretation. This court has said that we don't read the 11th Amendment precisely for what it says, but rather the broader presupposition that the 11th Amendment confirms. I think that if you want to overrule Hans, you would also have to overrule Alden versus Maine, Blatchford, and any number of this court's foundational precedents explaining that we don't subscribe to the diversity theory, but rather to understanding that just because it has common law origins doesn't mean that sovereign immunity isn't part of our constitutional design.
But if we're in a world in which we've already departed from the text of the 11th Amendment and we're trying to figure out how we can give effect to the written text of the 5th Amendment, why would we let kind of the penumbras and emanations from the 11th Amendment override a state citizen's right to just compensation to which that person is textually very clearly entitled.
Your Honor, I think in the sovereign immunity context, the general idea that somehow an implied form of a constitutional principle is less valid doesn't really work for the very reason that the United States' own immunity is also by implication. The U.S.'s own immunity is not in constitutional text, but we of course still say that the U.S. is immune until and unless it consents to be sued. And so as a general matter, we don't think that the implied versus express principle really works in the sovereign immunity context. But I do want to speak to your concern that maybe we're letting sovereign immunity get in the way. And I think that any conflict between these two principles is really a function of the way respondents have pled their claim. Generally speaking, for hundreds of years, the way that litigants were able to get private relief was by suing the individual officer directly. And I think this speaks to the earlier discussion about why that might be better. Generally speaking, because sovereign immunity barred the claim, those individual tort suits were able to get just compensation, as we saw from early cases like Callender versus Marsh, Black versus Republican, and all kinds of other early cases explaining that in those contexts we don't have to pick between constitutional principles. In this instance, respondent may still bring a Section 1983 claim, but of course, given the way that he has pled the complaint, when you have to pick between the two of them, history and original understanding points in the direction of picking sovereign immunity instead.
Well, you focused on respondents' conduct here, but I think we need to focus on the state's conduct as well. And one of the really significant facts is that the state decided to remove this case to federal court. And I guess I don't understand why that doesn't constitute a clear waiver of a sovereign immunity defense, because you were subjecting yourself to the jurisdiction of the federal court and suggesting that that was the appropriate place for this claim to proceed. And it seems like cases like Lapides really suggest that in that kind of circumstance, we should find waiver of immunity.
Your Honor, Lapides itself expressly declined to pass upon the case we have today because at the very beginning of its opinion, Lapides explained that we do not need to pass upon the scope of waiver in a case where the state has not waived its immunity in state court. And I want to make this point very clear because I think it's important to understand exactly what Lapides said. The rule going into Lapides was that any time a state voluntarily becomes a party to a case, of course that state waives immunity. And the reason why Lapides was willing to extend that rule to even an involuntary defendant was because of the fairness concerns that were at issue in Lapides, but not at issue here. I think an involuntary defendant never really voluntarily invokes the jurisdiction of any court. But in Lapides, the court explained that if we allow a state to first expressly waive immunity and then remove to get that immunity back, that would be deeply inconsistent and unfair.
But I understood the actual rule of decision of Lapides to be a little bit different, which is that to remove a case to federal court means invoking the judicial power of the United States, and it is fundamentally inconsistent with that invocation to then turn around and say the judicial power of the United States does not extend to the dispute because of state sovereign immunity.
So I think if that were the reading of Lapides, there is still a way to say that we didn't waive our immunity here. This court has recognized that sovereign immunity encompasses both an immunity from suit in a federal forum and an immunity from liability. And so you can read Lapides to say that removal might waive the former immunity from suit, but not the latter immunity from substantive liability. That's how at least 5 courts of appeals have read Lapides, to say that just because you've waived that immunity from suit objection doesn't mean that you waive your substantive immunity when it comes to paying just compensation. And so we still retain the right to assert that latter immunity in this case.
So can I ask you a Lapides question? It seems like you have sort of 2 ways around Lapides. One is to say it only applies, or it applies only when the state has waived its immunity in the state court first, number 1. 2, it applies, and maybe these work in combination, 2, it applies only when the removal is in some sense unfair. With respect to theory number 1, isn't that going to be awfully complicated to figure out, to dig into state immunity law, waiver law, to figure out whether or not this occurred in state court? And I mean, are we going to do this state by state by state?
We don't think so, Your Honor. There's no evidence coming out of the 4 courts of appeals which apply this rule to suggest that the test is awfully hard to administer. You know, respondents bring up the example of the Montana waiver doctrine, but I think that their own case from the 7th Circuit suggests that generally speaking, when the law is unclear, that kind of eerie guess just isn't that hard to apply. Their authority resolved the question in a single paragraph, paragraph. And in the mine run of cases, we still think that that would be true. Maybe there are edge cases that are hard, but there just isn't that kind of evidence of overwhelming difficulty in applying the unfair advantage reading of Lapidus.
But so we will potentially have 50 rules in 50 states.
Well, Your Honor, that's often true whenever we're talking about varying issues of state law, and I think federalism countenances the idea that there are going to be marginal cases that are a little bit harder to decide. And I guess our position is that even if there are marginal edge cases, the sovereign immunity principle is so fundamental to our constitutional system that those costs are well worth it, and there just isn't evidence from the courts of appeals that it is all that difficult to apply what you've described as the unfair advantage version of Lapidus.
I guess I'm still focused on this idea that you voluntarily invoked the jurisdiction of the federal court and suggested that was an appropriate forum. And I combine that with this idea that states, when they ratified the Constitution, saw right there in the Fifth Amendment the text saying that if there's a taking, you have to pay just compensation. And so there was explicit contemplation that there would be monetary remedies for this kind of conduct. And it seems to me like that adds up to an expectation on behalf of the states that by ratifying the Constitution, they were exposing themselves to the responsibility to pay for takings liability. Why shouldn't that be the proper way to understand the plan of the convention or what states understood when they agreed to enter into this union?
The best evidence against that, Your Honor, is the fact that the federal government was immune for almost 100 years until it decided to waive its sovereign immunity. I think it would be illogical for states to have looked to the only other comparator, the federal government, and said, well, you know, you're immune, but I surrender my immunity, given that states entered the system as co-equal sovereigns. Moreover, Your Honor, that doesn't change even when looking to the second founding, because at the 14th Amendment's ratification, the federal government was still immune, and in fact dealt with these claims through private bills or the kind of trespass claims we've been discussing. And given that the Takings Clause was not even incorporated against the states until 1897, I think that the history there counsels in favor of our position and not respondents when we're thinking about what the states would have been, I guess, on notice of when they ratified the Constitution. At the end of the day, when it comes to these sort of plan of the convention cases, the court has looked to compelling evidence of this kind of structural surrender of immunity, and there isn't that kind of compelling evidence. Rather, all the evidence points in favor of our position.
I'm wondering how much we can read into the history of the use of private bills to obtain just compensation in the federal system in a state where, at least by hypothesis as this case comes to us, there is no mechanism available for receiving just compensation either through the courts or through an administrative system or through a system of private bills. In that situation, wouldn't a state joining the union and seeing that there is some mechanism existing somewhere in the operation of government to provide that entitlement that is textually conferred by the Fifth Amendment, understand that it too is under an obligation to provide some mechanism that is going to create monetary obligations that it will have to fulfill?
That might be true, Your Honor, but the question here is whether the courts have the power to compel compensation if there isn't any kind of private bill in action. So taking as true that the private bills were the primary mechanism, I don't think a state necessarily would know that an additional step would be true, which is the court saying that we don't think what you're doing is good enough and we shall compel you to pay just compensation. I think the picture which emerges from history is instead that there was legislative discretion to set up a remedial scheme as the states and the federal government saw fit. And so there just isn't that kind of compelling evidence that states would have known, well, I must surrender my immunity to the kind of private suits that the founders thought were so antithetical to sovereign dignity and so important to shield against that they passed the 11th Amendment shortly after Chisholm versus Georgia.
Well, why wouldn't it be sensible to say that in a circumstance where the state itself is not providing any mechanism to comply with this constitutional guarantee, to that limited extent, it understood that its sovereign immunity would be waived? So in other words, maybe there's kind of a federalism gloss where states have primacy and they can enact some kind of mechanism at the state level and in state courts to provide the remedies the Constitution requires. But if they do what Ames has done here and absolutely refuse to provide any ability to go go into state court to get this remedy, then sovereign immunity will be waived in order to provide a federal forum.
I think that understanding would be at war with the history and original meaning of what the 11th Amendment was supposed to enshrine, and it would also run against this court's precedents in cases like Lynch versus United States, where it explained that sovereign immunity is all-embracing no matter the source of the right alleged. I understand that there is an instinct to say that we should pay Mr. Wells, and I think that the way around this instinct is not to say you should create a cause of action that automatically pierces immunity every time, but rather resort to the time-tested mechanisms that for hundreds of years were how litigants got relief. We point to cases like Callender versus Marsh, where this is exactly where the Massachusetts Supreme Judicial Court said, because sovereign immunity bars this claim, his remedy is either to sue the individual officer for trespass or to petition the legislature for redress. And the kind of novel exception respondent asks for isn't warranted in this case.
But why isn't the Chief's question tracking Reich versus Collins pretty closely, right? I mean, this is effectively what we said in Reich. That if you don't provide any remedies in state court, then you're out of luck.
So Reich we find a little bit hard to square with this case, this court's decision in Alden versus Maine. You know, Reich said in basically 2 sentences that you basically have a lesser claim to sovereign immunity in state court than in federal court, and we read Alden to pretty dispositively get rid of that distinction because Alden says that sovereign immunity is of equal constitutional importance in both state and federal court. But, Your Honor, just last term, this court cast even further doubt on the idea that Reich versus Collins can apply outside the taxation context at all. In John Q. Hammonds, the court explained that the unique interest that the taxation context evolves explains the holding of the tax cases. And so I guess at a baseline, we don't really see how Reich versus Collins can apply in this case. And to the extent that Reich does apply, Reich was pretty certain on the fact that federal court cases cannot proceed because the 11th Amendment does still bar those claims from proceeding in federal court.
I guess I tend to think of the claim at issue in Reich as somewhat more esoteric than the claim here. Unconstitutional taxation sort of up in the ether, whereas here you've got this plain as day constitutional provision that provides not just the right but the remedy. It seems to me that this case ought to follow a fortiori from Reich.
Well, I think the distinction the court drew in John Q. Hammonds was the cabin taxation to one island and then everything else to the rest. And so I don't think it's a question of how clear the right is. The right, of course, was also very clear in Reich in terms of the due process violation there. But rather, the distinction the court drew in John Q. Hammonds was to say tax is different, tax is special, and tax cases are dependent on the unique interest taxation involves, such that the holding of Reich should not extend to just about any case involving a monetary injury.
Why aren't takings also special?
Well, I think they're not special in the same way that tax is special. And I would look to the language of John Q. Hammonds in explaining that taxation involves unique government interests that respondent hasn't shown are relevant in the takings context. And of course, we recognize that the takings clause is an important right. And our position at a baseline is that this isn't the vehicle to redress the violation of that right, and that the separation of powers counsels for a more cautious and time-tested approach.
So I guess I'm a little bit confused by your answer, because I would think that the reason that taxation involves important governmental interests is because taxes are how the government collects the money that it uses to function. We're talking here about property that the government has taken because it needed to have some means of addressing an acute public health emergency. This seems like a pretty important governmental interest at stake as well. And on the flip side, we have an individual who is claiming a right to a certain amount of money as compensation for having lost private property to governmental use, which seems very comparable to the tax context. So I guess I would like to hear a little bit more about why we would draw a line between these two scenarios.
Well, Your Honor, I think the interest here is almost the inverse of the interest in the tax cases, because there you're talking about the government's interest in some kind of standardized scheme for collecting payments, and here you have an individual litigant asking for payment from the government. But even leaving that aside, Your Honor, we explained in our opening brief that if you were to apply Reich in this case, the remedy would still be to reverse and remand this back to state court for the state court to craft appropriate relief in the first instance, as that's been the remedy in every tax refund case.
Would you concede that if Mr. Wells sued a state official instead of the state itself, that he could receive the money damages that he's entitled to? Again, I'm curious what you're fighting so hard for, and I'm wondering if you're willing to make that concession.
I think that we would have to litigate that separately. It might not be us. It would probably be counsel for the officer. I think he'd have a colorable claim that qualified immunity does not bar his suit because the right here is clearly established. And taking the allegations as true, I think it would be a very reasonable claim to make. Because that is not before this court and Mr. Wells didn't plead it, I guess we don't really know how that claim would work. And for all those reasons, Your Honor, we respectfully ask this court to reverse.
Ms. Ollier, please proceed.
Madam Chief Justice, and may it please the court. My name is Panise Oliai, and I, along with my co-counsel Nicholas Nelson, represent the respondent Daniel Wells. I will be discussing why the Fifth Amendment's Takings Clause provides a cause of action, and my co-counsel will be discussing why Ames cannot invoke sovereign immunity. Chief Justice and members of the court, Ames cannot ignore the stakes of this case. It's pointed to a congressional action being the thing at issue, but the fact of the matter is at the end of the day, the Fifth Amendment's Takings Clause provides a cause of action because if it does not, Ames can invoke sovereign immunity, or Ames can invoke sovereign immunity to get around that cause of action. Ames can take whatever property it wants, whenever it wants, without ever paying a dime.
Please go ahead. So are you beginning with consequentialism? That just seems like a strange place to begin.
Not at all, Your Honor. We instead point to the will of the people in enacting the Fifth Amendment's Takings Clause. And we point this court to the text and structure of the Takings Clause as this court instructed in cases like Sandoval. In Sandoval, this court said that a law only provides a cause of action where its text and structure make that abundantly clear. And that's the only thing we point this court to today.
Didn't we say in Sandoval some version of, look, we've got to be clear that the text at issue, whether it's a statute or constitution, provides both a private right and a private remedy? Seems like the Takings Clause checks out.
Absolutely, Your Honor, and we'd agree with that notion, especially under this court's centuries-old money mandating inquiry. That inquiry simply asks whether a law provides two things, a substantive right as well as an express monetary remedy.
So I get, the reason I ask the question is it seems like you're awfully reluctant in your briefing to embrace either Bivens or the implied private right of action cases. I think I understand why, because as I said, they're sort of out of vogue. But it seems like you might say, this is the case. This is the unicorn. This is the one case. Why are you sort of fighting the friendly hypo, I guess?
Well, Your Honor, if this court were to find in favor of our client, certainly we would not complain. But we do not think this court needs to resort to the reasoning of Bivens or any other of the old forms of implied causes of action that it rejected in Sandoval. And that's because we can point this court to the text of the Fifth Amendment and say that the text provides, that its best reading is that it provides a cause of action.
And isn't the difficulty with your argument from the clarity of text that this is not at all how the Takings Clause was understood for roughly the first century of this nation's existence?
We think, Justice Kruger, that instead the history counsels in our favor. And here's why. In de Villiers, this court, Justice Thomas, writing for the majority, explained that the absence of a case under a Fifth Amendment cause of action does not mean that there is no Fifth Amendment cause of action. And that's because the history of the federal practice, as well as state practice related to this matter, reveal why. In the founding era, we saw a situation where, admittedly, there was the private bill system, but there was also another end to that story. And the story continued in the form of plaintiffs being able to bring writs of trespass and other common law actions against federal officials, and they were able to gain compensation by doing so. For instance, in the case Little v. Bareem, as early as 1804, individuals were able to bring actions in tort against federal officials. And in doing so, they were able to get compensation. We see the same exact thing happen in yet another case, Mitchell v. Harmony, where the plaintiff at issue was able to bring an individual trespass action against a federal official, and in doing so get compensation in the amount of $100,000.
But if that were so ubiquitous, why all the rigmarole with private bills? I don't really understand. Why would aggrieved individuals go to the trouble?
Well, Justice Newsom, we can imagine that private bills may have sometimes been an easier remedy for individuals. It would have ensured that Congress would have been able to hear them out, and maybe they would have been able to get a way to be able to ensure that their claims are quickly heard, rather than a court which may take more time.
Congress worked differently back then, huh?
Certainly, Your Honor. And indeed, it was the case that these private bill systems existed, to be sure, but they weren't the only situation. And in cases like Little v. Bareem, as well as Mitchell v. Harmony, we see plaintiffs bring a claim against a federal official for this very thing that we're asking today. Mitchell v. Harmony is especially instructive because that's a case where a plaintiff brought a trespass action against a federal official and was able to gain just compensation. And in that case, the federal official at issue argued that he was simply given orders, and that orders is all he was following.
Can I ask about how your theory works? If you think that there's a cause of action directly under the Takings Clause, can that substitute in for any state-level remedies, or do you think that this cause of action can only be inferred in a circumstance like this one, where the state of Ames has entirely flouted any ability at the state level to pursue a separate state-authorized cause of action?
Two responses to that, Chief Justice. In particular, first, this cause of action, we think the best reading is that it is always provided full stop under the Fifth Amendment's Takings Clause. But to your concern that state remedial systems would be displaced, rest assured we would never ask this court to do that. In fact, states can still invoke sovereign immunity, as my co-counsel will explain momentarily, when they have these remedial systems. But the fact is that the state of Ames has refused to do so at every turn. It has refused to offer anything resembling an administrative tribunal. It has not offered an inverse condemnation action or its equivalent, and it is the only state in the Union to not provide a state constitutional takings clause.
But to Justice Prelogar's question, to the Chief's question, sorry, she's the Chief to me, how could the takings clause, with respect to your backup argument that this applies where states have sort of turned their back on providing their own remedies, how could the takings clause, the same words, mean different things in different states? I don't think I understand that. Like, some states provide full remedial relief. Therefore, we needn't invoke the takings clause, the inherent cause of action. Some states don't. Therefore, the takings clause, as to them, means that there is a cause of action. I don't think I understand that.
Justice Newsom, the distinction that would explain this difference is the fact that sovereign immunity and a cause of action are two different things. As this court said in Larson, for instance, sovereign immunity is an independent question. It doesn't mean that where one doesn't have a waiver of sovereign immunity, one no longer has a cause of action. And so the cause of action, we think the best reading is that it always exists under the Fifth Amendment's takings clause. But states can invoke sovereign immunity where they have a remedial system. And so that would remedy any form of a state having a remedial system. The plaintiffs there would still be encouraged to use it, and the states need not worry that their systems would be displaced.
So does that mean that most state law inverse condemnation actions and other similar kinds of common law actions would, in any state that has waived its sovereign immunity with respect to such actions, would automatically be turned into federal constitutional claims?
Not at all, Justice Kruger. As long as those inverse condemnation actions remain available, we find that to be a sufficiently clear and understandable remedial system that does not allow the plaintiff to be able to override sovereign immunity in order to bring their cause of action.
But won't that raise questions about what it means to make the vindication of the right adequately available? You know, what if the state set the statute of limitations at 1 week, or took extraordinary steps to provide a forum but make it very difficult to exercise the right? At that point, would you say that the Fifth Amendment comes in as some kind of backstop via the self-executing cause of action? And if so, how are courts supposed to draw those lines?
Well, Chief Justice, we think that in those instances, we could say that there is actually no legal avenue provided. And that's the thing that's required under the Fifth Amendment's takings clause. It provides a cause of action because it ensures that there must be some legal avenue.
But there is one. It's just you have to bring your claim quickly.
Certainly, Your Honor. But I think at this point, this court, for instance, on that question, could find that constructively that cause of action is being barred because it's simply too difficult for a plaintiff to bring something underneath it. And in that sense, that cause of action would then have to kick in. Even though it's permanently there, a plaintiff would not be able to gain access to waiver of sovereign immunity until such a legal avenue has been foreclosed. And the state of Ames has done that at every turn. Moreover, we think that this reading of the Fifth Amendment's takings clause, the best reading, as we put it, is also what explains the Tucker Act and how it's been operating for decades of precedent, bringing takings claims under that act. Our friends on the other side, as we noticed in the colloquy earlier tonight, have not been able to explain just how takings claims under the Tucker Act work.
Well, they seem to say that you can infer through the Tucker Act that Congress definitely wanted the remedy to be available, and so I think I understood them to essentially be saying the Tucker Act itself supplies the cause of action, even if we haven't necessarily understood it that way. Can you respond to that?
Certainly, and happily, Chief Justice. In the case of the Tucker Act, this court has said in United States v. Borms that it only provides two things: waiver of sovereign immunity, and a grant of jurisdiction. But neither of those two things are a cause of action, and a plaintiff needs a cause of action in order to be able to proceed under a Tucker Act claim. This court has said as much in National Mutual Insurance. And so we have to look to some source of law to provide that cause of action, and this court must look to the Fifth Amendment's takings clause because there is nothing else that provides a cause of action.
So can I ask you a question about this? So your answer to the Chief calls up, in my mind, I've always thought of there being sort of three big buckets in a lawsuit. One is the jurisdiction bucket. Bucket one is the jurisdiction bucket. Bucket two is the cause of action bucket. Bucket three is the merits bucket. And inside the merits bucket, there is right and remedy. But you seem to be saying that where there is a right and a remedy, necessarily bucket two gets filled up. I don't think I understand that. It seems to me that right and remedy are just in bucket three. They can't fill bucket two. But it seems that you need them to fill bucket two.
We think that these buckets, as we would phrase them, are things like sovereign immunity as one bucket, jurisdiction as another, and the cause of action as that additional bucket. And we think, as Sandoval has recognized, the inclusion of a private right as well as a private remedy made express on the text of the law at issue provides that cause of action. And that's been the case under the centuries-old money mandating inquiry that this court has employed. The provision of those two things made clear on the text of the Constitution provide that cause of action. And decades of historical practice by state constitutional takings clauses also make this clear. For instance, in the case Sinixon v. Johnson, the New Jersey Supreme Court used this very money mandating inquiry to identify that the state constitutional takings clause, in that case, the New Jersey state constitutional takings clause, provided a cause of action. And notably, that takings clause is near identical in language to the federal constitutional takings clause. The same thing applies in yet another case that our friends on the other side have no response to, Johnson v. City of Parkersburg, in which the Supreme Court of West Virginia, again relying on their state constitutional takings clause, identified that there was a cause of action. And these 19th century cases are crucial, Your Honors, because they demonstrate that in the 19th century, when the more formal, rigid system of trespass writs began to fall away, into the more modern pleading system that we see today, courts leapt in to ensure that there was a legal avenue to be able to access.
And so is your point in emphasizing the 19th century cases that by the time the 14th Amendment rolls around, or at the very least that by the time we decide in 1897 that the takings clause is incorporated, now there's a judicial understanding, or sort of a Supreme Court level understanding, that the takings clause has this built-in cause of action? And if so, does that mean that there is this built-in cause of action for states under the 14th Amendment, but not for the feds under the Fifth Amendment?
Not necessarily, Your Honor. We point to the 19th century cases to demonstrate the fact that the courts have gone to such lengths to demonstrate that there must be a cause of action available under the Fifth Amendment's takings clause, that there must be a legal avenue to vindicate just compensation. But that does not necessarily mean that this only really kicked in at the time of Chicago-Burlington in 1897. Instead, that's just when the 14th Amendment incorporated the Fifth Amendment against the states. And so that's when we would say that this cause of action began to apply to the states, but it had always applied to the federal government because it simply meant that there must be a legal avenue available to plaintiffs to be able to vindicate their right to just compensation. And we see that in those early federal cases that I had mentioned, things like Little v. Bareem, as well as Mitchell v. Harmony. All these cases demonstrate the exact same thing, that there was always a legal avenue available. And because there was always a legal avenue available, plaintiffs didn't turn to something like the Fifth Amendment's takings clause. They hadn't needed to.
That also means that if we turn to the Fifth Amendment's takings clause, there are going to be a whole host of difficult questions about who can be sued and whether Section 1983's limitations, for example, should be imported in under the self-executing takings clause, and what should the statute of limitations be. And I'm not sure I understand the lines you'd have us draw in sorting out those questions if we're going to infer this cause of action.
We're not worried about those concerns as much as our friends are, Chief Justice, and that's because the questions of things like the statute of limitations and the class of defendants are easily answered, as you'll see in our brief itself. As we've demonstrated, the statute of limitations is fairly clear. As this court has said in North Star Steel Company v. Thomas, when a federal law does not provide the statute of limitations on its face, we look to the most closely analogous cause of action. And usually that's an inverse condemnation action, but since the State of Ames refuses to provide one, we look to the next most closely analogous cause of action. And in the State of Ames, that's injury to real property. And that's 5 years, as stated on the record, unequivocally. Moreover, the class of defendants is coextensive with that of the 14th Amendment state action doctrine because it incorporated the Fifth Amendment's takings clause against the states. And so it's a simple question of which defendants are available.
Doesn't it seem a little weird with respect to the class of defendants that this implied inherent cause of action that you're asking us to recognize would be broader than the express cause of action provided in 1983, because we know that 1983 doesn't reach states as a matter of statutory interpretation, but yours would.
Not at all, Justice Newsom, and two responses to that. First, we don't think it would be odd because the Fifth Amendment's takings clause was not a mere congressional enactment. It was a decision made by the people. And so the fact that 1983 has later come along and Congress has specified different ways through which one could vindicate a sort of tort or constitutional right claim against an official does not mean that the federal constitutional takings clause right has to be something that's limited to the same class of defendants. The state action doctrine is not something that's merely limited to 1983. It just tells us that in a Fifth Amendment's takings clause context, the appropriate defendants are the state and state arms, things like the hospital system in this case, as this court said in Howlett. And in this situation, we also see, for a second reason, that this is no concern before this court. And that's because this court made a similar decision in the context of habeas corpus. Turning to the suspension clause, we see that it is similar in language to the Fifth Amendment's takings clause. They are the only two constitutional provisions to provide an express remedy on their face. And this court in Boumediene v. Bush identified that the suspension clause ensures legal access to be able to vindicate one's writ of habeas corpus. And because that's been the case, it's demonstrated that this court is able to find that legal avenues must be available in these cases where a novel sort of circumstance has come along.
Your friends on the other side suggest that the legal avenue that's available to you is a 1983 suit. It solves everybody's problems. It solves the federalism concerns. It solves the separation of powers concerns. It gets you what you want. What's the problem with, if we remand this case and allow you to amend your complaint, why not just add a 1983 claim?
Well, Your Honor, we'd be overjoyed if we had access to 1983, but Daniel Wells does not. And that's because Section 1983 has never been something that this court has found can lie against an individual defendant for a takings claim. And it's clear why. In the context of a trespass, for instance, you have an individual tort. An individual is the one who commits the trespass and steps on the land and therefore must pay damages in that case. But in the case of a constitutional tort or a constitutional violation, instead what we see is that the government is the one that lays claim to the title of land. The government is the one that benefits from the taking, and it is, as this court said in First English, the government that must pay just compensation. And so a 1983 action, Justice Kruger, cannot lie against an individual defendant in a takings context, and this court has never found that.
Why couldn't you sue the individual defendant and, would be indemnified against the state? The state would ultimately be the one paying the damages. I'm not sure why that wouldn't be an adequate substitute. Why does the state itself have to be the defendant, even if we know that the public official was carrying out the taking on behalf of and to benefit the state itself?
Well, for two reasons, Chief Justice. And the first is that in the 1983 context, this court has never identified that that could be a theory that lays. And that's because, as mentioned, the government is still the one laying claim to the title of land. Daniel Wells would not be able to sue every single state hospital employee that stepped on his land for the just compensation that he's due. But second, and perhaps more importantly, nothing else like a cause of action in trespass could also lie against the state of Ames or the state hospital system or its officials. And that's because in de Villiers, this court found it so important to ensure that there was a legal avenue actually available that it asked the state defendant in that case, the state of Texas, to identify an instance in which, and I see I'm out of time, Your Honor, if I may finish?
You may.
Thank you. It asked for a specific instance in which the state recognized a trespass or inverse condemnation claim to bring a cause of action in takings. The state of Texas cited to City of Baytown v. Strzok, and in doing so, it demonstrated that there was a legal avenue. Ames has had ample opportunity to do the same, and it has failed. And as such, we ask that this court affirm the decision below and find that the Fifth Amendment's takings clause provides a cause of action. Thank you.
Thank you. Mr. Nelson, you may proceed.
Madam Chief Justice, and may it please the court. My name is Nicholas Nelson, and I represent Daniel Wells. Sovereign immunity is not a license to seize property free of charge, but the state of Ames believes otherwise. Ames argues that it can use its sovereign immunity to take Mr. Wells's property and then forever deny him his constitutionally guaranteed just compensation.
Can I ask you a version of the question that I asked your friend on the other side? You sort of flirt with the language of the 11th Amendment that it applies only to suits brought by citizens of other states, are you sort of implicitly asking us to walk back Hans?
Not at all, Your Honor, and I'd be happy to explain that point. So the Takings Clause is unique in the Constitution in that it provides an affirmative obligation on the state to pay government. But that's not true of any other provision of the Bill of Rights. Every other provision of the Bill of Rights creates a negative on government power that can be vindicated in ways that are entirely consistent with state sovereign immunity. For instance, if a state passes a law that infringes your right to free speech, you could seek an ex parte Young injunction to restrain enforcement of that law. Or if the state prosecutes you under that law, you could raise the First Amendment as a defense in a judicial proceeding. But here, because the state has the affirmative obligation to pay you money, you have to go knock on the government's door and ask for that just compensation. And if state sovereign immunity would allow them to slam the door closed, you'll be left empty-handed and there's truly no other avenue for you to obtain just compensation.
But you could have gotten an injunction potentially. I mean, you suggest that with these other negative rights, it's the government has to stop doing the thing that's unlawful. And here the unlawful thing is, don't take my property unless you're going to pay for it. So why isn't that a sufficient remedy in this context?
We don't think so, Your Honor. There would not have been, Mr. Wells would not have been able to obtain an injunction before the actual taking occurred because nothing on the face of the governor's executive order is itself unlawful. It just authorized the hospital system to go requisition property. Nothing in there said that it wouldn't be allowed, or the state hospital wouldn't pay Mr. Wells for the property when it did the taking. So the government was acting completely lawfully until the moment of the taking when it chose not to compensate Mr. Wells. And with respect to after the taking, Mr. Wells couldn't enjoin the government to say, get just compensation through an injunction. As this court said in Edelman v. Jordan, Ex parte Young can't be used to sort of smuggle a claim for monetary relief against
But the government
state.
held on to the facility in question for a matter of years, if I read the record correctly. So at some point, at the end of a year, couldn't Mr. Wells have gone to court and say, if you're not going to give me money, then at least give me my facility back?
That might be true, Your Honor, but even as this court said in First English, the compensation remedy is required by the Constitution even for a temporary taking. So for any period of time where the state of Ames held on to Mr. Wells's property and did not compensate him for that period, it is liable to pay just compensation. And so to your earlier question, Justice Newsom, we are dealing here with a head-on collision between the right to just compensation and state sovereign immunity. There is no other way for Mr. Wells to obtain just compensation if the state of Ames can successfully invoke its sovereign immunity here. And normal rules of construction, when we have sort of an irreconcilable conflict in the same law, would require us to favor the express right to just compensation over implied background principles of state sovereign immunity.
I guess this question is sort of a hybrid for you and your co-counsel, but I'm going to ask you since you're the one at the podium. I mean, is it necessary that every right prescribed in the Constitution has a judicial remedy?
Not necessarily, Your Honor, but in this situation, if the state of Ames is able to invoke sovereign immunity against this affirmative obligation, it could categorically wipe the just compensation right in the state of Ames off the books. And
well, not necessarily. I guess this is why I ask about judicial remedy, right? Because the 11th Amendment only precludes judicial remedies. So is it necessarily your position that a violation of the Just Compensation Clause, if you will, requires a judicial remedy?
Absolutely, Your Honor. And I think if you look at the framing of the 14th Amendment, that would actually help demonstrate this. Representative John Bingham, when he introduced the 14th Amendment, said that one of his primary objectives with this new provision of the Constitution was to repudiate this court's holding in Barron v. Baltimore, which held that the Takings Clause doesn't apply to the states. And other radical Republicans, like Senator Jacob Howard, for example, lamented the fact that states at the time of 1868 were flagrantly violating citizens' property rights. And furthermore, Representative Hale indicated that Section 1 of the 14th Amendment is self-executing and entrusted to the judiciary because the radical Republicans were concerned that legislatures and the political branches wouldn't do their job to always vindicate individuals' constitutional rights. And so
I was curious about your Section 1 of the 14th Amendment argument. And in particular, I was curious about what limiting principles you're supposing or proposing with respect to that argument. I mean, it seems like taken to its logical conclusion, that could be understood as a waiver of sovereign immunity against all incorporated rights under the 14th Amendment. So how are you drawing the lines?
So the line, Madam Chief Justice, is whether a cause of action is being able to lie against the state because of the 14th Amendment. And so because the takings clause is already complete in itself in providing both a private right and a private remedy and therefore a cause of action, it is incorporated against the states through Section 1 of the 14th Amendment.
So this hinges on us agreeing that there is in fact a cause of action. If we disagreed with you on QP1, then you agree that this would fall out of the case, this particular argument against sovereign immunity.
Your Honor, admittedly, I think the Fitzpatrick comparison would be a bit harder to make, but I do still think our Reich v. Collins line of reasoning would hold. To elaborate a bit more on the Fitzpatrick reasoning, this court held in that case that when Congress creates a cause of action pursuant to Section 5 of the 14th Amendment, that can operate free and clear of state sovereign immunity because the substantive provisions of the 14th Amendment, namely Section 1, by their express terms evince a limitation on state sovereignty. And as this court later described it in Seminole Tribe, the 14th Amendment as a whole fundamentally restructured the federal-state balance at the expense of state sovereignty.
But just in terms of blocking and tackling, you're not suggesting that there is any piece of congressional legislation that has done the abrogating here?
No, Your Honor.
It's just sort of Section 1 abrogation, naked Section 1 abrogation.
That's correct, Your Honor.
And is that a thing? Have we ever done that?
No, Your Honor, but I think that's because there's no other provision quite like the Takings Clause. The Takings Clause is the only provision of the Bill of Rights that provides a cause of action in itself. And so if that is enforceable against the states, it's only because of Section 1 that it's enforceable. And Section 1, as this court has said, evinces a diminution of state sovereignty. And so that provision of the Constitution would be enforceable against the states absent their state sovereign immunity. And to an earlier question Madam Chief Justice raised about whether or not this would disrupt state remedial systems, I don't think this court needs to go that far. As this court said in Larson, specifically referring to the Takings Clause context, the question of state sovereign immunity can turn on the availability of other remedial systems. So in that case, it was discussing the previous case of United States v. Lee. It noticed that the officers there did not enjoy sovereign immunity protections and explained that in part because the Court of Claims was not yet available to vindicate takings claims under the Tucker Act. But later on, when that was available, the court there said that that could influence whether or not the sovereign enjoyed sovereign immunity. And so we think
what is the principle behind that? I guess I'm having some difficulty understanding why the protections of sovereign immunity would expand or contract with respect to whatever the right may be at issue, depending on the availability or not of alternative remedies and a court's judgment as to whether or not those remedies are adequate.
Absolutely, Your Honor. I think it probably turns on the idea that this right needs to be able to be vindicated somewhere. And so the State of Ames can't just rely on its sovereign immunity to nullify the right to just compensation completely. And I think you see a similar idea in the tax refund cases that Justice Newsom raised earlier. That is the only other context where this court has ever held that a state has an affirmative obligation to pay money. One of them was First English, and the other dates back to Atchison in 1912, and then the tax refund case is reaffirmed in McKesson in 1990. And critically in that case, Reich v. Collins, this court said that clear and certain remedy to recover unconstitutionally levied taxes needs to be available, state sovereign immunity notwithstanding. And so I think this court could rely on that same principle here to say that the State of Ames, so long as it's refusing to provide any clear and certain remedy, does not enjoy state sovereign immunity in its own course.
And how do we explain that limitation? Just because it seems like it's a good idea? Or where do we find the basis for it in the text of the Constitution?
So the tax refund cases base those in the due process clause. And I took my opposing counsel up here to basically concede that Ames is actively violating the due process clause right now by foreclosing every other avenue to obtain just compensation. And so long as that is true, the State of Ames cannot close the final door by invoking state sovereign immunity against the takings clause's
Well, Ms. Lee has said that part of this is about how you pleaded your case and that actually you had other alternatives here that you didn't avail yourself of. And so why should we assume that the door is completely closed and that there weren't other adequate remedies?
So for some of the reasons that my co-counsel described, I don't think various remedies were available. Section 1983 couldn't lie against any individual officer. The State of Ames has failed to cite any case in its two briefs or in its oral argument tonight where trespass has been available against the State of Ames in its own courts. And so for that reason, the takings clause's cause of action is the only available remedy here for Mr. Wells to seek just compensation.
Can I ask you, you mentioned the Tucker Act a minute ago. Can you circle back to that? Is the waiver of sovereign immunity on the Tucker Act superfluous?
No, Your Honor.
Tell me why, because it seems like to the extent that your contention is that the takings clause sort of forecloses application of the 11th Amendment, which is written into the document itself, it seems like that would apply a fortiori to the feds who don't really have a textual hook for their sovereign immunity. It just sort of exists in the ether.
Absolutely, Justices. I'd be very happy to explain the difference. So, dating all the way back to Chisholm v. Georgia and throughout this court's entire sovereign immunity jurisprudence, it has repeatedly disclaimed any connection between federal sovereign immunity and state sovereign immunity doctrine. In Chisholm v. Georgia, for example, the justices of this court looked at the text of Article 3, which contemplates both states as defendants in federal court and the United States as defendant in federal court. And it said, that completely gets rid of state sovereign immunity, but that doesn't do one iota of harm to federal sovereign immunity. And I think the reasoning that Chief Justice Jay offered in that opinion explains why. Their judgments against states or hailing states into federal court can be effective because it has the power of the federal government behind it. But it would sort of be tilting at windmills to try to hail the federal sovereign into federal court under federal law. There'd be no higher political sovereign to appeal to in order to enforce any judgment against the United States unless the United States consents to that. And so to succinctly answer the question, I don't think this court needs to worry about federal sovereign immunity being damaged in any way if it holds that the state of Ames does not enjoy immunity here. Furthermore, my friends on their side, the only response they offer to not applying Reich v. Collins here is pointing to Alden v. Maine and John Q. Hammonds, but neither of those cases support their point. Alden v. Maine actually went out of its way to distinguish Reich v. Collins because of the sovereign immunity language in that case. And it held that that case was not about Congress's Article I powers and their ability to abrogate sovereign immunity. It instead said that Reich v. Collins was based on the Due Process Clause itself, and that the Constitution itself gave rise to that obligation to pay money. The exact same thing is true of the Takings Clause here. The Due Process Clause creates that obligation on the states, as this court held in Chicago-Burlington, and so that would give rise to the same reasoning of Reich v. Collins.
Can I ask you about your case-specific waiver argument that by removing this case to federal court, the state waived its sovereign immunity? And I guess I'm wondering why that necessarily has to be so when obviously the state was consenting to a federal forum. But I don't see why the state should have been put to the choice of having to waive its immunity if it wanted to exercise that right to a federal forum.
So 2 points to that, Your Honor. So first, the state courts are the experts here in addressing state sovereign immunity questions in the vast mine run of cases. And that's because, as this court said in Alden v. Maine, when we're asking the question about whether a state has waived its immunity, we're going to look at state statutes and state constitutions, and we're going to look at how the state courts have interpreted those same provisions. And so the state of Ames, their own courts were the experts here in resolving the question initially about whether there was an express waiver. And second, I think it's a little strange for the state of Ames to stand at this podium and say that its state courts were not sufficient. The state of Ames can staff its own courts. It can change the jurisdiction of its own courts. It can change the venue rules to more favorably, result in good rulings on state sovereign immunity grounds.
So are you suggesting that states don't really have a right to removal, or that it would always be nonsensical for a state to think that it's better off litigating in a federal forum?
To be sure, if there is a federal question that the federal courts are better at addressing, then yes, of course, the state should be able to remove that case.
I mean, this is a federal constitutional right. There's a clear federal question here, and I'm not sure why you think that states are better equipped to enforce and vindicate that right.
Your Honor, as this court said in Lapides, when it's laying down these jurisdictional rules about state sovereign immunity waivers, it needs to be taking into account all of the different types of cases that could be arising, because jurisdictional rules need to be clear, and the litigants need to know the rules of the game before they step into court and start filing claims and motions. And it also said that an innocent motive in a particular case cannot make the critical difference. I'd also like to stress that the reasoning of Lapides was not based on whether a state had waived its immunity before removing. As Justice Kruger correctly pointed out earlier, it was instead based on a century-old line of cases dating back to Clark v. Barnard in 1883 that have consistently found a waiver of sovereign immunity whenever a state involuntarily invokes the federal jurisdiction. And my friends...
But there is an issue of potential manipulation or gamesmanship if, in fact, there's a waiver in state court and then you remove to federal federal court only to assert immunity. And, Lapides did reserve this question, right? So even though I understand that the rationale might not have been based expressly on this point, why aren't those adequate distinctions of the case?
Your Honor, to be sure, Lapides did not squarely address that question, but the reasoning of the opinion was based primarily on whether a state voluntarily invokes federal jurisdiction. It cited the Clark, Gunter, and Gardner line of cases over 20 times by name in the body text of the opinion.
Do I remember correctly that the states were plaintiffs in those cases?
The states intervened in those cases, but I think it's very important to understand how Lapides characterized those cases. Those cases were not about a state voluntarily becoming a defendant, as my friends on the other side characterized them. Instead, it read those cases to stand for the general principle about voluntarily invoking federal jurisdiction. And the important thing here is that states should not be allowed to invoke federal jurisdiction and then speak out of both sides of their mouth and point at the 11th Amendment and say, never mind, there is no federal jurisdiction in this case, send it back down to state court or dismiss it. Furthermore, my friends on the other side tried to get around this by pointing to circuit practice that has characterized sovereign immunity as having sort of a dual character. It's both an immunity from liability and an immunity from the jurisdiction or the forum itself. But that theory originates in a Fifth Circuit panel decision in 2005 called Myers v. Texas, that the court there self-consciously noted that this was a novel theory of state sovereign immunity that had no basis in this court's precedents. And I think that's very important to understand. This court has never held that state sovereign immunity is an immunity from liability. As James Madison and as John Marshall said, it's an immunity from being hailed to the bar of a state or federal court. It doesn't give states an additional right to go around violating valid federal law. As this court said in Alden v. Maine, states still have their obligations to adhere to federal law under the Constitution itself, even if they have this privilege of state sovereign immunity. This court has repeatedly rejected the English historical notion that the king can do no wrong and that the king is not bound by the law. That does not form the basis of state sovereign immunity doctrine in this country. Instead, it's based on the relationships of the states vis-a-vis the federal government and whether or not they can resist being hailed to a court to answer and assess their liability in that forum. And so because the state of Ames here voluntarily invoked federal jurisdiction, it cannot get around that by pointing at the 11th Amendment and saying that we do not have to litigate here. As a final matter, I think it would be remarkable for this court to hold that the express text of the Fifth Amendment creates a cause of action, but nevertheless implied background principles of state sovereign immunity can override the clear will of the people. For the foregoing reasons, this court should affirm the judgment below. Thank you.
Rebuttal, Ms. Lee?
Thank you, Madam Chief Justice. I want to close out today with 2 points on each issue. The first point I want to make is why a constitutional cause of action is meaningfully different from the alternative remedies available in this case. And I want to begin by noting that Nick itself was a case by this court, which was a Section 1983 action against a government. That was a takings claim, and that was strictly brought under 1983. So the proposition that this court has never recognized that theory of liability is strictly false as a matter of precedent. We think that avenue was available to respondent. Qualified immunity would have been, much less relevant in that case, and we're not sure why respondent didn't pursue the claim. Moreover, Your Honor, I think as a general matter, it's important to understand that actually both sides agree on a lot. We agree that, generally speaking, there were common law trespass remedies, and that was the settled way for litigants to get just compensation, irrespective of sovereign immunity. I think the burden on the other side is to show you why that proves there is a constitutional cause of action in the Fifth Amendment, and we suggest the very fact that litigants proceeded under writs of trespass or action on debt or actions of injectment show you that there is no cause of action under the Fifth Amendment, because then surely litigants would have used that cause of action instead of having to separately invoke the procedural vehicle of that writ in order to get into court. On the second issue of sovereign immunity, Your Honor, I want to sort of gesture at this idea that, we all understand that Mr. Wells wants his money, and I think that is a very, understandable goal. But at the end of the day, this court has said that when it comes to sovereign immunity, the slate on which we write is anything but clean. That comes from Allen versus Cooper, and it was this court's recognition that sovereign immunity is governed by a series of precedents, rules, and understandings about history, and that we can't just make exceptions whenever we feel like it's required. In this instance, no exception is required for Mr. Wells. He could have pursued alternative avenues which did not run up against sovereign immunity because that represents the delicate historical balance that prevailed for hundreds of years, including, for example, trespass suits and ex parte Young. I think respondent's theory at the end of the day does not have much of a limiting principle. He suggests that there is something special about this constitutional cause of action, but any cause of action that is founded upon a Bill of Rights provision that is self-executing necessarily is also incorporated and therefore would constitute an automatic abrogation of sovereign immunity under respondent's theory. That would require walking back cases like Garrett and Kimmel, where this court has said, we don't think there's been a valid abrogation of sovereign immunity, and there is no reason to do so in this case. Last, I want to speak to this idea that this court has ever conditioned sovereign immunity on remedies before. Larson, which my friends cite, was a suit against an officer. It was not a suit against a sovereign. In that case, sovereign immunity was taken for granted, and the court recognized that the dispositive question was whether the suit against the officer was really a suit against the sovereign, in which case that suit would be absolutely barred. At the end of the day, there is no reason to rewrite the rules just for Mr. Wells. We think this court should stick to its precedents and reverse the Ames Circuit's judgment. Thank you very much.
Thank you, counsel. The case is submitted.
All rise. You may be seated. All rise. Please be seated.
We have concluded our deliberations, and we are not going to keep the teams or the audience in suspense. So we'll announce the winners of the various categories and then offer some brief remarks about the incredible competition that we saw tonight. Best Oralist is awarded to Sophie Lee. Best Brief is awarded to respondents. And Best Team Overall is awarded to respondent. The level of advocacy that we saw tonight was truly extraordinary for both teams. This was an incredibly hard decision, as the length of our deliberation probably reflected, and it's because you all did an incredible job. I write and argue cases for a living. I don't normally judge them, and I've got to say, reading your written work product, your briefs sung, they were incredibly clear and well-crafted. The level of oral advocacy tonight, you all were unflappable. It was amazing that whatever we threw your way, you handled with grace, under pressure, and with total clarity of thought. And it was really remarkable to see that. I want to acknowledge as well just the support in the audience tonight, the support of your teammates who prepared the oral advocates tonight for this competition. The case writers wrote a great problem. We all found the competition issues themselves to be fascinating. And I'll just say, too, on a personal note, I'm a graduate of Harvard Law School and an alum of the Ames Moot Court competition, and I made it all the way to the finals, where sadly, in a decision I still think is unjust, my team did not win. I'm here to tell you life goes on, but you know, it's really a full circle moment to see the competition thriving with this incredible level of advocacy and attention to detail, and so I really want to thank you for the extraordinary performance tonight. Justice Newsom.
I just couldn't agree more with the Chief. I think Justice Kruger and I would agree that if we could see this level of advocacy day in and day out in our courts, we would be extremely happy about that. This was leaps and bounds, frankly, better than what we see from even the very best lawyers. I always tell my law clerks that if you learn nothing else from me during your year, you will learn that you are going to be a terrific lawyer. You guys are going to be terrific lawyers. And I think the Chief has made a very important point. The four oralists here today, they sort of got the limelight and they worked hard for it. But the people sitting behind them worked their tails off to get them ready for this. And Chief Justice Prelogar and Justice Kruger have done a whole lot more oral arguments than I have, but even the oral arguments that I prepared for in the Supreme Court, not one of them went by where I did not learn just critical information from my moot courts and from my teammates about what to say, what not to say, how to say it, how not to say it, how to respond, how not to respond. And so it really is a team effort, but this was just astonishingly good. I just can't tell you how good the briefing was and the oral advocacy was. You're all to be congratulated. Thank you very much.
I couldn't agree more with everything my colleagues have said. I'll just start off by saying, again, this was really not an easy decision. You all made it very tough on us. Everything that you presented by way of your briefing and your oral advocacy here tonight was really just such a pleasure. And as Justice Newsom says, we really would be very lucky if you one day decided to come argue a case or two in our courts. You, I think, demonstrated by what you did tonight one of the best and most exciting and rewarding things about oral argument, which is that these are, at the end of the day, really conversations. They're conversations about difficult legal issues in the law, where you, through your exceptional preparation and your presentation, help us as the judges figure out how to resolve the most difficult issues that arise in our system. And I think everything that you displayed at the podium today really reinforced that sense of being in conversation with us, of being there to help us work through those issues, even when we didn't sound like we very much wanted that help. Whatever you do with the skills that you have honed and put on display tonight through this very impressive moot court program, the world is going to be very lucky to take advantage of them. You all have very bright futures ahead of you. So thank you for the privilege of being part of this, and best of luck to you in all that you do next.
All rise. Thank you very much for coming to tonight's AIM final. Have a great evening.